Welcome to U.S. Immigration TV, and thank you for watching. Now, the Child Status Protection Act, or CSPA, is complex, confusing, and can be extremely frustrating. Now, during my 40 years of practicing law, I'm always encountering cases where a child may have been petitioned many years before their 21st birthday. But by the time their visa is available or their priority date is current, they've aged out. And then they're told they're no longer included in the petition and they must be left behind. So now the family is left wondering, why did my child age out? How come the CSPA doesn't apply? And is there anything that can be done? Well, I have some good news for some aged out children. A recent Second Circuit Court of Appeal decision, now Second Circuit is one level below the U.S. Supreme Court, well, a decision by that court has held that if a parent naturalized after their child's 21st birthday, the child may still be eligible for CSPA benefits based on the child's statutory age instead of their biological age. Now, before this case, the child was simply out of luck if the parent naturalized after the child's 21st birthday. Now, does this perhaps apply to you or your case? Now, by way of background, the Child Status Protection Act provides age-out protection for certain children if they turn 21. For children of U.S. citizens, their age is locked in if the parent filed the petition before the child's 21st birthday, or if the parent naturalized before the child's 21st birthday. For other family and employment-based petitions, there is a complex mathematical computation to calculate the child's age. Basically, what you do is you subtract the processing time of the petition from the child's age when the priority date becomes current. And then the child must apply for their visa within 1 year. Now, under this scenario, a child could have two different 21st birthdays. The first is their biological 21st birthday, which is 21 years after the date they were born. Simple enough. The second is their statutory 21st birthday. And that's where the government, or USCIS, excludes or subtracts from the child's age the time the government spent processing the visa petition. So, for example, an immigrant files an F2A petition for their daughter when the child is under 21. Now, F2A is minor child of green card holder. Okay, now, the child is then 22 years old when the F2A visa becomes available or the priority date is current. However, it took 2 years for the government to process her petition. In that case, her statutory age for F2A purposes would be 20 years old, making her still eligible under the Child Status Protection Act for an F2A visa. Now, in this recent court case, the parent petitioned her minor child in the F2A category, and that's minor child, a green card holder. But then the parent later naturalized after the child's 21st birthday. Now, even though the child may have been eligible for a visa under the CSPA mathematical computation, based on her statutory age at the time the parent naturalized, the family was told that because the parent naturalized after the child's biological age, the child was no longer qualified under the Child Status Protection Act. The Second Circuit Court of Appeals sided with the child and applied the statutory age, noting that the legislative history of the CSPA shows a clear desire by Congress to fix the age-out problem for all minor beneficiaries, and there is nothing to suggest that Congress intended to exclude beneficiaries like this child. The court concluded the CSPA dictates that in determining whether an F2A beneficiary is a minor, we use a statutory formula rather than pure biological age. To hold otherwise would put the family in a worse position because the parent naturalized. The court further noted that penalizing people for becoming citizens runs counter to the entire family-based visa scheme. Now, in this case, because the child was still statutorily under 21 years of age on the date her parent naturalized, she was eligible for a visa as an immediate relative. And so that's very good news. Why? I've come across many cases where an immigrant parent petitioned their minor child in the F2A category, and in fact the child qualified for age-out benefits under the Child Status Protection Act. But then after the child turned 21, the parent had naturalized, and as a result, the child was refused their immigrant visa because they no longer were considered a minor. Now, this case can offer new hope for families in that situation. So if this situation applies to you, I strongly recommend that you consult with an attorney who can, of course, evaluate your case, do the mathematical computations under the CSPA, and determine if there's hope or your child is eligible. Also, if your child has ever been refused a visa for aging out and was told the CSPA doesn't apply, you may also want to consult with an attorney. In fact, I've had many situations where a child was denied because the consul or the USCIS officer had said the child was not eligible under the Child Status Protection Act, and thankfully we were able to convince the embassy or the USCIS to reconsider by showing the child was eligible. But of course, I'm not giving a guarantee that in every case the child will be eligible. Also, and this is another warning, if a parent has already filed an F2A petition and the child has already turned 21 years of age, don't rush out and naturalize as a result of this case by assuming that your child will still be eligible. There is still a mathematical computation that has to be performed to make sure the child's age would still be under 21 on the date of naturalization. However, I truly think that this case could be helpful to many families where they had qualified under the Child Status Protection Act, but the parent had mistakenly naturalized after the child's 21st birthday. I hope you found this video informative, so don't forget to like, share, and most importantly, subscribe to this channel, and we will keep you constantly informed on the latest immigration news, developments, and changes that could benefit you or somebody you know. I'm Michael Gurfinkel, and this is U.S. Immigration TV.